whenever anybody from the McKenzie Friend world, actually, whenever any of them reach out to me and act like they want to be my friend, I'm always dubious. And I was rightly dubious about DJ. I don't care because I didn't ever know anything that I wouldn't have let a homeless person on the street know. What I would say, she doesn't know who she is. I know who she is more than what she knows who she is. She's a gopher, and we'll get onto her a little bit later. But let me tell you a story about reviews, self-appointed gatekeepers, disappearing YouTube videos, police complaints, forensic IT specialists, and an apparently top secret court injunction nobody's actually shown me. Couldn't write this shit. Because this story has now become so ridiculous that I genuinely do not know whether I need a solicitor or a detective or the cast of Scooby-Doo. Before we begin, everything I discuss will either be something I can evidence, something contained in correspondence sent to me, an honestly held opinion, or a question I believe deserves answering. If I get anything factually wrong, send me the evidence and I will correct it. No issue, no problem. That, my friends, is how accountability works. So how this begun? Let's have a link. The issue is actually very, very simple. Find a McKenzieFriend.com has material concerning me on its website. I do not want it to be listed. I do not want to be listed there, promoted, advertised, or represented, or connected with that organization in any way, shape, or form. I've asked it to be removed many times since 2023. It's not complicated, is it? Remove my profile. I've even removed my profile, removed my photograph, removed my details, remove anything suggesting I'm even associated with an organization. Click, delete, confirm, done. Probably about, 3-minute job, including making a cup of tea. But no, instead of simply removing me, the situation has grown arms, legs, several websites, police complaints, YouTube complaints, legal threats, and now apparently an injunction, which anything except pressing delete. Anything except pressing delete. The bigger concern. This is not merely about my profile. There is a wider question about how McKenzie Friend platforms operate, how reviews are handled, how complaints are checked, how litigants are referred, and how much genuine scrutiny takes place before somebody describes themselves as a professional McKenzie Friend. That title sounds impressive, but professional McKenzie Friend is not the same thing as being a regulated solicitor or barrister. It does not automatically demonstrate qualifications, competence, insurance, accountability, or independent regulation. That does not mean every McKenzie Friend is bad. It means the public should ask questions. Who verified this person? What experience do they actually have? Who handles complaints? What happens when something goes wrong? Is the complaint investigator genuinely independent? What evidence has been checked? Those are not attacks. They're basic consumer protection questions. For vulnerable parents, if an organization promotes people who support vulnerable parents in the family court, its check-in processes should be exceptionally robust. These are not people choosing somebody to clean their windows. They may be dealing with allegations of abuse, safeguarding concerns, and decisions affecting their children. Getting it wrong has consequences, big ones. The reviews. I created a platform on which people can share experiences and reviews. Find a McKenzie Friend now challenges statements that certain reviews came from paying customers and says, I must preserve the proof of payment. Fine, I will preserve it. It's preserved. Don't you worry about that. It's preserved. I'll preserve the reviews, correspondence, payment information, metadata, and relevant records. Nothing will be destroyed or altered. Nothing. But preservation works both ways. They should preserve their review records, complaint records, internal communications, website changes, communications with YouTube and other platforms, and everything sent to their alleged forensic specialists. Disclosure is a wonderful thing. People love demanding evidence right up until somebody asks to inspect theirs. The disappearing video. Oh, yes. Over 11,000 views. Complaints were made about my video, and YouTube removed it for a short period. This is now being presented in their email as though the Supreme Court heard the case, handed down a judgment, and Lord Chancellor personally the delete button. No. It was a platform moderation decision, and the video was reinstated. Don't shoot the messenger. Don't shoot the messenger. Let me be fair. Reinstatement does not prove that every word I say is legally correct, just as removal did not prove that it was unlawful. Platforms make platform decisions. Court make legal decisions. Big difference, Prince. Big difference. They're not the same thing. This is where you see the intelligence of these people. Right? Then you've got the police. Okay. Then come the suggestion that matters had been reported to the police. Again, I did smile. Not because genuine police involvement is something to dismiss, because it's not. But anybody can contact the police and make a complaint. Making a complaint does not establish that as a crime has occurred. You may well have called them. You may well have said something. If the police want to speak to me, they know where I'm at. I will engage properly, take legal advice, and provide the relevant evidence. No problem. No problem at all. But we have gone to the police. It is not a magic spell. We do not just say, 3 times and suddenly turn criticism into like a criminal offence. No. You can't clip your heels. Oh, look, I'm in charge. Criticism of my website and criticism of what I've said. Can we turn that into a crime now, please? Can we turn that into a hate crime? Please. The email. Now that we arrive to the latest episode. I've received an email accusing me of, are you ready for this? Defamatory publication, harassment, intimidation, unfair competitive practices, and repeated infringement of our intellectual property rights. It's quite a big shopping list. We've apparently gone from please stop criticising us to an entire legal advent calendar. Every paragraph opens another allegation. I'm so scared. The email also says, our forensic IT specialists have completed an analysis. Forensic IT specialists. It sounds like somebody has called in CIS McKenzie Friend. Woo. They're making up new roles. Presumably, they have discovered that I own websites, publish videos, and use the internet. Okay, outstanding detective work. Well done, Inspector Gadget. Well done, you. But jokes aside, they have evidence, provide it. Through proper process. Identify every statement complained of. That's going to take some work. Quote the exact words. Provide the URL. These are basics. I'm just giving you hints here of what you're going to need to do when you're supposed to serve these letters, which wasn't included, by the way. Give the date. Explain the meaning allegedly conveyed. Explain it. Say whether it was claimed to be false, statement of fact, an opinion, harassment, misuse of information, or intellectual property infringement. If intellectual property has been infringed, identify the work, prove ownership, and identify the alleged infringement, if you know how to do that. Do not simply throw every legal phrase into an email and hope that one of them sticks, please. Do you think dealing with the mystery injunction? This is the other one that we get to my favourite part. Their email refers to, you ready for this? Our recently obtained court injunction. Okay. What injunction? Okay. What, they served it to you? Did they served it on you? Which court? What's the claim number? When was it made? Who are the parties? What does it prohibit? Because I've got plenty more videos. Does it actually name me? Does it name me? Because I'm sure they're going after you, Prince. Does it bind me? When was it served? Because if you tell someone that you have obtained an injunction affecting their websites, producing the sealed order should be fairly straightforward, right? An injunction is not Voldemort. You're allowed to say its name. Send the order. If it exists, and applies to me, of course. I'll take immediate legal action, advice, and comply with any obligation that genuinely binds me unless the court varies to or discharge it. But mentioning a mystery injunction in a threatening email does not establish that an order exists against me. Evidence first, theatre second. Their demands. Now ready. They demand that I remove all material concerning their organisation. Prince Dominic, Rosie Taylor, and everybody connected with them. Everybody. This is an extraordinarily wide demand. They have not identified every statement. They have not explained which specific words are supposedly false. They have not particularized the damage allegedly caused by each publication. Am I supposed to be taking this seriously? They effectively say, remove everything. That is not how I properly particularized media and communication complaints should work. But do I need to write it for you? Meanwhile, my request remains considerably shorter and very much more simple. Remove me from your website. That's it. That is it. I do not want to be listed there. I do not want my image there. I do not want my details there. I do not want anybody believing I am connected or endorsed by that organization, because I'm not. Why is that simple request apparently so difficult? Public discussion and third parties. Now, they also demand that I stop encouraging other people to publish material. Really? Come on. For clarity, I am responsible for what I publish, and for anything else I actually instruct or encourage others to publish, I am not responsible for completely independent people discussing information already available to them. But I will not told anybody to harass, threaten, or abuse these individuals, because that's not what I'm about. I'm about love. Yeah. Love and speaking truth. Don't like it? Truth hurts, doesn't it? Turn to love. Do not do that. Yeah. Do not turn to hate. That's not me. I'm not a hater. I have nothing personal against anybody. Not even you, Dominic, apart from the fact that you refuse to remove me from your website. It's that simple. Accountability does not require a mob. It just doesn't. My response is straightforward. I deny unlawful conduct and make no admissions. I have requested the sealed injunction, court, and the claim number, parties and terms, proof of how and when it was allegedly served, the precise words complained of, the alleged defamatory meanings, the claimed factual inaccuracies, evidence of serious harm or serious financial loss, and proper particulars of every alleged intellectual property infringement. I have confirmed that I will preserve relevant evidence. I have required them to do the same. I have also renewed my data protection request, requiring them to identify what personal information they hold, where they publish it, their lawful basis for processing it, and why they refuse to remove it. And I've offered a sensible route forward. Remove my material, confirm the removal, properly identify any remaining complaint, then explore whether the dispute can be resolved without proceedings. That is reasonable, more than reasonable. And why this matters? The wider issue is bigger than Prince and bigger than me, much bigger. McKenzie Friends often work with frightened and vulnerable people. Parents may have lost contact with their children. They may be exhausted, traumatized, and desperate for help. Anybody operating in this field should welcome proper scrutiny. Competence matters. Transparency matters. Honest reviews matter. Fair complaint handling matters. The answer to criticism is evidence, not threats. Labels or attempts to erase every uncomfortable discussion from the internet doesn't work. Equally, critics must be accurate. That includes me. If evidence shows that I have made a factual error, I will correct it. If somebody disagrees with my opinion, they are entitled to explain why. What nobody gets is immunity from scrutiny, merely because scrutiny is uncomfortable. So here we are. Police reports, YouTube complaints, forensic IT specialists, solicitors, and the mystery injunction. All apparently easier than removing my details from a website I've repeatedly asked to be removed from. My response is calm and uncomplicated. Show me the order. Show me the evidence. Identify the precise statements. Remove my information. Until then, I'll continue to preserve the evidence, ask legitimate questions, and deal with any genuine legal correspondence through the appropriate process. No threats, no harassment, no invented allegations, just facts, evidence, and accountability. Because when somebody turns up with a smoke machine gun, dramatic music, and a folder marked legal action, there is still one question that matters. What can you actually prove? Now, here's what's bizarre. Shortly before this legal email arrived, somebody I'd trusted, who I will refer to as Deborah or just DJ, she asked for my email address, which was unusual because there appeared to be no obvious reason for that request. Plus, it's all in the public domain. She had previously approached me with various problems and disputes. Eventually, I made it clear that I did not want to be involved in more drama, because every time she spoke to me, it was to do with drama from one of these little clowns, some cowboys. And I could see it weeks ago, months ago. She was literally, I'd say that I was like something, and she was exactly the same. They call it love bombing, I think. I could see it happening all the way through. I know you're taking a lot to trust me, Jason. You don't trust anybody. I trust everybody, darling. You clearly don't know me at all. You clearly didn't know me. You clearly didn't know that I knew all the way along. With Jay, darling, Jay. So, shortly after that correspondence, find a McKenzie Friend email arrives, and it was her that brought it to my attention about these police, because she wants to create drama. Now, let me be precise. I do not currently have proof that Deborah supplied my email address to them. I don't really care if she did or didn't. I am not presenting that as an established fact, but the timing has caused me to ask questions. Now, why did she suddenly need my email address? What did she intend to do with it? Did she share it with anybody? Why did she not check my public domain? Why did she just not check her emails before? Because she has got my email address. Was there any communication between her and Find McKenzie Friend, or anybody acting on its behalf? Those are legitimate questions, and relevant electronic records should provide those answers. What makes this particularly concerning is that I trusted this, I gave her passwords and that sort of stuff. I've given her access to parts of my website and shared information with her. She had told me that trust mattered to her. I extended trust in return. Following these events, I withdrawn that access, secured my systems, and preserved the relevant messages and access records. I find it all very bizarre how she called me yesterday going, I'm associated by, I'm going to get associated with you because I'm associated with you and I don't want to be associated. And she removed her. This is how much I trust you. I'm so grateful for your trust, and they don't trust anybody. I trust everyone. Now, this is not, look. This is not an foundation of criminal conduct. A sensible response to a suspicious sequence of events. And you have to trust these people. This is what I'm saying, right? I'm bringing this to you. This is what they're doing to me. This is what they're doing to me because I'm not following their rules, right? They say they want to help you. These are the people. Find McKenzieFriend.com. Phil Cage's UK network. These are the people that work on these networks. This is how they treat people. And they're saying they're helping you. If there is an innocent explanation, it can be provided. If she did not share my details, she can confirm that clearly. She doesn't really care if she didn't. If my information was shared, it doesn't matter what, I'm entitled to know what was shared, with whom, and for what purpose. I'm not going to manufacture certainty when I only have suspicion, but I see everything. I hear everything, and I know before it's even landed. So, but I'm not, there you go, that's that. That's just how it is. INFJ. Deborah, you'd know what that is, wouldn't you? I also need to correct another piece of misinformation circulating in this situation. I have not been arrested at all. The police have not contacted me at all. No one has. Somebody is making a report to the police. That is not the same thing as police finding an offence has occurred. That's not the same thing at all. It's certainly not the same as somebody being arrested, charged, or convicted. So what they do and what they're doing now in this letter is actually they're projecting what they've already done to themselves. To me, they're saying that I shouldn't be doing it to them. I am not going to say that the police will laugh at them. That would be childish. That would be really childish. And presumptuous as well, maybe. If the police contact me, I'll deal with them properly and give them respect and take legal advice. But let us be turning up a reported allegation into imaginary arrest. That's nonsense. Much of this dispute appears civil in nature, particularly the threatened claims about defamation, data protection, and intellectual property. However, allegations such as harassment can potentially involve criminal as well as civil lawsuits. So that is precisely why I will not dismiss genuine police contact, but neither will I pretend that a complaint proves anything. The position today is very simple. I have not been arrested. I have not been charged. I have not been shown any injunction that binds me, that stops me from mentioning McKenzieFriend.com and the cowboys that are there. If somebody claims otherwise, they should produce evidence and correct that claim. Tell me they're not cowboys. Tell me they're not cowboys. Prove it to me. It's about the evidence. But do not call it in as an attack. And do not state reduced traffic as a fact without an analysis, and frame it as criticism of the organisation and a question about timing and commercial motivation. And look, who was being criticised? They're talking to me about criticising this bird that I can't remember the name of now. There's another important distinction being blurred in their email. This is where this was never intended as a personal campaign against, what's her name? Taylor Rose, whatever her name is. I don't know. That's how important she is to me. My criticism arose from statements she chose to make publicly on a podcast while presenting herself in a professional McKenzie Friend capacity. Once somebody speaks publicly about family court practice and vulnerable litigants, that what they say can legitimately be examined, challenged, and corrected. That is what I've done. My criticism may have been blunt. It may have been uncomfortable, but the central issue was professional competence, the accuracy of the information being communicated, and the organisation promoting or associating itself with that individual. The primary subject of my criticism has always been find a McKenzie Friend as a platform. No individual, the platform. If the organisation promotes somebody, presents them as competent and benefits from that association, it cannot completely distance itself when the public professional statements attract scrutiny. Prince's first priority should have been to examine what was said on that podcast. What was accurate? Was it responsible? Could a vulnerable litigant rely upon it and be misled? What checks had been completed before that person was promoted? Instead, the response appears to have been to focus on silencing the critic rather than addressing the substance of the criticism. That is the real story here. And why intervene now? Yeah, let me just say why intervene now. Why has Prince become so heavily involved now? This is genuinely about protecting individuals from unlawful conduct, or has the public criticism begun affecting confidence in the platform, its reputation, website traffic, inquiries, or commercial performance? I do not currently possess their private analytics, so I cannot state that as their traffic has fallen. That would be a speculation. But their email alleges harm and threatens damages. Therefore, if proceedings are issued, a financial loss is claimed. The evidence should show that. What their traffic was before publications and what it was after. Whether inquiries or revenue has changed. Let me do the job for you. I'm doing it for you, Prince, yeah? I've got a pen handy. What actually caused any change and whether other explanations exist, okay? Everyone can use this as a training lesson on how to make a claim. If their business has suffered because people saw accurate information and started asking reasonable questions, that is not automatically defamation. If anything I published was materially false, identify the exact words and provide the correct evidence. That is the difference between accountability and censorship. You do not answer professional criticism by repeatedly shouting, harassment. You answer it with facts, evidence, facts. And people trust you to support them in family court. This is what I'm saying, folks. This is how people don't realize how stupid they are. This was not about Rosie's private life. It was about public statements made in a claimed professional capacity and the platform that promoted that claimed professionalism. If the information was accurate, prove it. If my criticism was factually wrong, particularize it. But do not rebrand the scrutiny of a business as a personal campaign simply because scrutiny has become a commercially uncomfortable profession. Remove me from your site. Thanks.